meeting to order. Welcome to meeting number 40 of the House of Commons Standing Committee on Finance, pursuant to Standing Order 1082 and the committee's motion adopted Tuesday, April 27th, 2021. The committee is meeting to study Canada Revenue Agency's effort to combat tax avoidance and evasion. Today's meeting is taking place in a hybrid format, pursuant to the House Order of January 25th, 2021, and therefore members are attending in person in the room and remotely using the Zoom application. The proceedings will be made available via the House of Commons website, and for your information to witnesses, MPs certainly know this, the only person that will be visible on the screens to the public will be the person that is speaking, and we ask you not to take pictures of the screen when those are not visible. Just one other comment before I go to Mr. Julian's point of order. There was a complaint about me putting committee business in the last half hour of this meeting, and it is there because we do have to farm out sections of the Budget Implementation Act to other committees. If we're going to give them the time to decide how they're going to handle their work, we have no choice but to meet on that today. There just isn't any other options, and Zoom time is very tight for capacity. But we have managed now to extend the meeting by a half hour, so it will give us 2 hours for the Canada Revenue Agency efforts to combat tax avoidance and evasion, as we were committed to, and then we'll go to half an hour for business. So just so that's clear. Mr. Julian, point of order.
Thank you, Mr. Chair, and I thank you for obtaining the extra time. I still think that the witnesses that we're bringing forward today are important witnesses. This is a study that we have waited 5 years to undertake in the Finance Committee. And so with respect, this is a very complicated motion that Mr. Fraser is putting forward. We really haven't had notice of motion. Next week on Monday, we were looking to schedule the steering committee meeting. We have a committee meeting on Tuesday as well. And I think that is the time to go in with the appropriate notice into the very lengthy motion that we've received just shortly before this meeting. So I appreciate your efforts to get some additional time. I feel very strongly that we should consider Mr. Fraser's motion fully, but that's Monday and Tuesday where we have meetings that we have already set up. So that was my point of order.
Okay, just to comment on that, the problem as of yet is we haven't got a time due to the Zoom capacity on Monday. And my reading of the Budget Implementation Act, and I believe Mr. Fraser's motion is the same, it looks at farming out 12 different committees, the workload. And look, if we leave it any longer, it means we'll have to deal with our own problems. But I really don't feel right imposing on other committees and making it near impossible for them to do their job. So I don't think there's any choice but to meet on this today, but that's the committee's decision. Mr. Kelly, on the point of order.
Speaking very briefly on the point of order, that I agree with Mr. Julian, and I'd prefer that we go forthwith into the witness testimony. And this, I haven't even seen this motion, so I don't know if it was put on notice or if there was a draft or something circulated. I haven't even seen it yet, and I'm not prepared to debate it.
All right, Mr. Fast.
A similar comment, Mr. Chair. The study we're undertaking now involves complex issues of tax evasion, tax avoidance, and very concerning, troubling cases where Canadians have suffered as a result. So why would we undermine the ability of the witnesses that we've already brought to the table to have the full time available to them to provide the testimony they need and for us to ask those questions. We've set aside time to discuss some procedural issues, some committee issues. Let us do it within those time frames. These committee meetings already are often truncated by votes, and we don't get a chance to ask the questions that we had really expected to. So again, I'm hoping you, Mr. Chair, will allow us to proceed with the committee as was originally scheduled.
That's what I'm trying to do. We have 2 full hours on tax evasion as was planned. We have set a half an hour following that for committee business, Mr. St. Marie, and then we're going on to, or we're going to take more time away from our witnesses.
Oui, rapidement, je suis d'accord avec.
Quickly, I agree with the past 3 speakers.
Okay, then we will move to committee witnesses, and we'll have that discussion starting at once the 2 hours is up. Thank you to all the witnesses for coming today. We will start with the Honourable Percy Down, Senator, and as certainly Senator Down knows, try to keep your opening remarks to about 5 minutes, and that'll make more time for questions later. Go ahead, Senator Down. The floor is yours.
Great. Thank you for the invitation to appear before this committee. And in the short time available, I would like to discuss problems I've identified at the Canada Revenue Agency regarding overseas tax evasion. As a parliamentary budget officer stated, there are hundreds of millions, if not billions of dollars in taxes that go undeclared, unreported, and that escape Canadian tax authorities. At the conclusion of my remarks, I will propose some suggestions to correct these problems for the committee to consider. My attention was first drawn to the problem of overseas tax evasion in 2008, when one bank disclosure in Liechtenstein showed that 106 Canadians had over $100 million just in that one bank. A couple of years later, another disclosure from a bank in Switzerland showed that bank had 1,785 accounts held by Canadians. The minimum account to open a bank account in that bank was $500,000. Then we had the leaks of the Panama and Paradise Papers, thousands of accounts involving thousands of Canadians. Among many glaring examples of inaction by Canada's Revenue Agency is the Panama Papers, disclosed over 5 years ago, listing 900 Canadians with accounts in that one law firm in Panama. Since then, other countries around the world with citizens identified in the Panama Papers have collected over $1.36 billion in taxes that were owing to them. Australia has recovered over $172 million, Ecuador, $105 million, Spain, $209 million, and even Iceland, a country of 370,000 people, has recovered $32 million. In the case of Canada, 5 years later, no one has been charged and no one has been convicted for tax evasions from the Panama Papers, and no charges or convictions from Liechtenstein or Switzerland. Meanwhile, the Canadian government doesn't even know the size of the overseas tax evasion problem. The Parliamentary Budget Officer has been trying to estimate the tax gap since 2012, but the CAR won't cooperate. For a comparison of what actions a country can undertake, look at what Australia has done about overseas tax evasion. They established Project Wick and Buy in 2006, when 8 government agencies came together to, in their words, protect the integrity of Australia's financial and regulatory systems by cracking down on use of illegal tax havens. The Australians in that time period collected over $750 million. A number of people were charged, a number were convicted, and they concluded Project Wick and Buy by establishing the Serious Financial Crime Task Force. In Canada, in the case of Liechtenstein, the CRA, in their words, waived referrals for potential criminal investigations to gather information. In other words, the agency promised not to charge the people involved in that tax scheme in exchange for them explaining to the CRA how it actually worked. However, any lessons learned from the Liechtenstein affair in 2008 have obviously not been very effective, since no one has ever been charged or convicted for all the additional leaks over the last 12 years. Because the CRA has been so incompetent in overseas tax evasion, a number of things have happened. One, we don't have the money to fund our priorities. Two, the rest of us have to make up the shortfall by paying more taxes. And three, Canadians are wondering why we have a two-tier justice system for tax evasions. Try to cheat on your domestic taxes, and the CRA will likely fine you, charge you, convict you, and force your repayment. Check their website, you'll see the results. Hide your money overseas, and you'll likely never be charged or convicted. Again, check their website, and you'll see the results. Canadians might want to ask why people are being treated differently, depending upon whether they're evading their taxes at home or overseas. Colleagues, I would suggest the following measures for the committee to consider. 1, measure the tax gap. 2, change the law so that it becomes an automatic criminal offense to have an undeclared account overseas, and those who don't declare their overseas account will automatically serve jail time. 3rd, introduce beneficial ownership legislation so we know who actually benefits from financial transactions. And finally, change the salary structure at the Canada Revenue Agency to retain experienced and specialized employees. Too many of them are being recruited by the other side for substantial salary increases. Thank you, Chair.
Thank you very much, Senator Down. Turning then to, as an individual, Janet Watson. Ms. Watson, welcome. The floor is yours. Go ahead. You're muted, Janet. We do it all the time, so it's not unusual.
This is my 3rd Zoom call today. You would think I would know better. However, good afternoon. Thank you very much for allowing me to appear before the committee this afternoon. I'm here to represent the thousands of victims of various frauds that were uncovered back in 2005. I'm referring to Mount Real, North Shield, and Sinar. The loss in the Mount Real case alone was approximately $120 million, and there were 1,600 victims. I was one of them. I believe that I was invited to address this committee to give my perspective on what it is like to be a victim of this type of crime. Believe me, it is not a victimless crime. One of the Mount Real victims that I got to know over the years was an Italian immigrant who came to Canada with very little money. He worked very hard, established a good business, raised a family. He lost approximately $2.5 million. His family told me he died a broken man. He never saw justice for his loss. There are hundreds of other stories. People forced to delay their retirements, others forced to go back to work in their 70s. There have been marital breakdowns, stress-related illnesses, and at least one suicide that I know of. I was one of the lucky ones. I lost the $68,000 that was in my RRSP at the time. Fortunately, I was still able to retire. I retired when I was 60. I'm now 74. I've been working on this case for a long time. And I became the unofficial spokesperson for many of the victims over the years. During the trial of Lino Matteo, who was the head of Mount Real, I listened to statements given by some of the victims. It was heartbreaking to watch men in their 70s break down and cry because they had lost what they thought would be a legacy for their children. The stigma of being this kind of victim is real, and many victims have still not told their families about their loss. Where did all the money go? Well, we were told by the RCMP that they were unable to investigate these massive frauds because they did not have the resources to trace the money once it has left the country. The trustee of Mount Real was Raymond Chabot Grant Thornton. They were only able to recover about $5 million of the $120 million that was lost. And the costs incurred in recovering these fees, in lawyers' fees and trustees' fees, was approximately $3.5 million, which left very little to be distributed to the victims. I'm very appreciative of the work done by the investigative journalists at the Fifth Estate and Enquête, who may have shed some light on where some of this money ended up. I am grateful to the Finance Committee for allowing me to testify today, and I hope that the inquiry, which was started in 2016, will be reopened into specific offshore tax havens. Thank you very much.
Thank you very much, Ms. Watson, and thank you also for your courage for sticking with us for 14 years. Turning then to KPMG, Ms. Lacavili, Canadian managing partner on the tax end, and Lucia, we did get your note that you sent to committee in both official languages, so all members should have that. Go ahead, the floor is yours. Oops, we're not hearing you either, and you look to be off mute, but we're not getting any sound. Clerk, can the technicians check that? Do you want to try it again, Lucia? No. Just on your little thing on this cord, just make sure the mute's not on and it. Sometimes that happens.
Can you hear me now?
Yep, we got you.
Oh, perfect. Okay. Thank you for the invitation to appear before this committee. I am KPMG's Canadian Managing Partner for Tax. Before I commence with my remarks, I'd like to extend my sincere sympathy to Ms. Watson and all of the other victims of the CINAR fraud. We know that you've been seeking answers for a long time, and I wish that we could help you. We simply do not have any connection to CINAR. We were not their auditor or their tax advisor. We did not help any of the people who carried out the fraud to take your money or hide your money. At KPMG, we ensure that our clients are able to work within the tax system, achieve their goals, and pay the tax that they are required to pay. That is the lawful tax planning work that we do for our clients across Canada every day and in accordance with KPMG's policies, practices, and culture, ensuring the highest standards of integrity, compliance, and professionalism. Like most professionals, as CPAs, we are required to protect the confidentiality of information regarding our clients and former clients. We take that obligation seriously. Where we receive a legal order requiring us to disclose client information, we comply with it. In February 2017, for example, in accordance with the CRA requirement, we provided the CRA with all the names and all of our files related to the OCS implementations in the Isle of Man. I would also like to address recent reporting by the CBC, which is focused on 4 corporations referred to as the sword companies that were established in the Isle of Man in the early 2000s. It's alleged that these companies were used to facilitate the CINAR fraud. I don't know whether that's true. I do know that any implication that KPMG had anything to do with the CINAR fraud is false. Any implication that KPMG was in any way involved with the sword companies is also false. We can state this with confidence because we undertook the comprehensive and detailed due diligence of our files, records, and personnel. We combed through millions of pages of documents. We reviewed our time and billing systems. We examined our client file databases, and we interviewed people. We took the added step of reviewing publicly available corporate documents from the Isle of Man. Through all of this, we found nothing that suggested that KPMG had any association with the sword companies. We provided this information to the CBC, making it clear that they were mistaken, but they persisted in publishing irresponsible and misleading stories. As a result, our lawyers served a notice of libel on the CBC last week. The CBC's allegations mistakenly rely on emails written 15 years after the fact by a woman named Sandra Georgeson, and similarities between the Sword companies and KPMG client companies. Let me address these mistakes one by one. KPMG, like other firms, commonly uses the support of corporate service providers to set up and help administer companies. There are a lot of these firms that do this work around the world. Ms. Georgeson worked for one such firm in the Isle of Man. In the early 2000s, KPMG in Canada offered a legal tax plan, known as the OCS. The OCS required the incorporation of companies in the Isle of Man, and Ms. Georgeson's firm was retained to do so. 15 years later, she was asked by her new employer to prepare a list of these companies. Her recollection in 2015 was that the Sword companies were examples of KPMG OCS implementations. They were not. In its reporting, the CBC pointed to the sequential registration numbers, named directors, signatories, and the filing addresses as similarities between the OCS and the Sword companies as evidence that KPMG set up these companies. The CBC is simply wrong in drawing this inference. These similarities exist because whoever registers the Sword companies use the same corporate service provider as KPMG. But the fact is, our diligence shows that the Sword companies do not belong to, nor are they in any way connected to, KPMG. I wish that we could help reunite the victims of this fraud with their money and bring the perpetrators to justice, but we can't. KPMG simply does not possess any information that could assist with the SINAR investigation. Putting the CBC's unfounded theories about SINAR aside, the broader issue that is before the committee today is how Canada can combat aggressive tax avoidance and tax evasion. We applaud the committee's review of this important issue. We share the committee's desire, and we welcome the opportunity to contribute to the discussion today. Thank you.
Thank you very much, Lucia. Then turning to the Professional Institute of Public Service of Canada, Ms. DeVoe, President, and Mr. Campbell, Economist. I guess we're going to you, Ms. DeVoe.
We are. And thanks for having us. My name is Debbie Davio, and I'm president of the Professional Institute of the Public Service of Canada, or PIPS, the national union that represents some 12,000 auditors and other tax professionals at the CRA across the country. Our members are skilled professionals and knowledgeable tax experts who ensure powerful corporations and wealthy individuals remain just as accountable as the rest of us. With me today is Mr. Ryan Campbell, our union economist and my technical advisor today. We'd like to thank you for the opportunity to present our views on this critical issue. Together, we'd be happy to answer any and all questions you may have after our presentation. We've researched this issue from the point of view of tax professionals at the Canada Revenue Agency and produced 3 reports on tax avoidance and evasion. You can find them on our website at pipsc.ca, and I'd be happy to forward copies to the committee members as a follow-up to this meeting. Few Canadians enjoy paying taxes, but they understand it's important to do it. Taxes fund the public services that make us healthier and safer, protect the environment, and nurture a stable economy in which businesses can thrive and compete. A healthy tax system is defined by fairness and integrity. The rules must apply to everyone. Unfortunately, many wealthy individuals and corporations use their superior resources to look for a shelter or haven where the tax rules don't apply. While these privileged few get a reduced tax bill, governments lose revenue for public services, resulting in either service cuts or tax hikes for everybody else. Excuse me. In February of 2018, we conducted a survey of professional staff at the CRA, including auditors, managers, forensic accountants, economists, statisticians, and actuaries. Their responses were eye-opening. Much of the criticism leveled at Canada's tax system is that, while it is designated to be fair, it's easier for some to get around the rules than it is for others. In our survey, 9 out of 10 tax professionals at the Canada Revenue Agency agreed that it's easier for corporations and wealthy individuals to evade and or avoid tax responsibilities than it is for average Canadians. Environics research put that same question to the general public and found that 8 out of 10 respondents felt the same way. You should find it troubling that CRA professionals with special knowledge of the inner workings of the tax system were more likely to agree than an average Canadian. Over 8 out of 10 also agreed that tax credits, tax exemptions, and tax loopholes disproportionately benefit corporations and wealthy Canadians compared to average Canadians. When asked if multinational corporations shift profits to low-tax regions, even when there is little or no corresponding economic activity taking place in that jurisdiction, 3 out of 4 respondents agreed. When asked if the CRA has adequate audit coverage capacity to ensure tax laws are being applied fairly across the country, only 16% of respondents agreed. When asked if training and technology advancements within CRA have not kept pace with the complexity of tax avoidance schemes, 79% of the respondents agreed. All of these survey results confirm one basic fact. Canadians deserve a rigorous examination of the tax system. Our CRA professionals are amongst the best in the world at what they do, but they face great challenges. Their job is to go after individuals and entities that, in effect, have unlimited resources and can aggressively exploit legal and international gray areas for their own gain. The CRA employees, by comparison, often feel outgunned by those trying hardest to avoid taxes. In 2012, sweeping budget cuts were introduced to the agency. Even with the more recent government reinvestments, it still doesn't have all the tools and staff it needs to get this job done. Does this make any sense when the Parliamentary Budget Officer's own numbers show a $5 return for every dollar invested in combating international tax evasion and aggressive tax avoidance? Does this make sense at a time when government spending has skyrocketed to deal with the social and economic impact of the pandemic? We need to fix this now. More than ever, Canadians need the tens of billions of dollars in tax revenue, if not more, that are sitting in offshore tax havens. We believe that a number of steps can be taken to correct the situation. First, we need better enforcement of existing tax laws. One of the simplest ways to make the system fair is to ensure that the same rules apply to everyone. Second, we need to prevent political interference at the CRA. This was particularly visible during the previous decade when the CRA was accused of shifting its focus away from big tax cheats to individuals, charities, and small businesses. Third, because CRA officials are frequently put in precarious situations where they're asked to hold powerful players to account in a high-stakes setting, whistleblower protection is crucial to ensuring professional integrity is paramount during the tax assessment process. Fourth, while government investments in the CRA have increased in recent federal budgets, Canada's population continues to grow, and so do the amount of commerce and the complexity of tax evasion schemes. The CRA needs to hire more technical advisors and invest in technology and training to deal with these factors. Fifth, the CRA must enhance the capacity of its regional offices. The Auditor General has found that taxpayers receive different treatment from the CRA depending on where they live and who they are. Its regional offices need the appropriate resources to ensure laws are applied fairly from coast to coast. And finally, a number of policy reforms need to be undertaken. Budget 2021 announced initiatives that, when implemented, will take tangible steps in the direction of tax fairness. These include a digital service tax for companies like Netflix and Amazon, and the creation of a publicly accessible beneficial ownership registry. These are both important initiatives long championed by PIP's members and our allies in civil society. While these changes are welcomed, we still have work to do. The Parliamentary Budget Officer has estimated as much as $25 billion of corporate tax revenue is lost to tax havens every year. We must do more to end the transfer pricing and profit shifting that facilitates this destructive practice. As of now, some incremental steps are being taken, but there are a variety of additional actions that can be put in place. The end result would be a new, simplified view of the global commercial landscape, one in which corporations can be prevented from pitting countries against each other and are taxed fairly everywhere. So in conclusion, CRA professionals must receive the training, tools, and resources they need to do their job. The CRA must receive appropriate funding to ensure tax laws are enforced equitably and that wealthy individuals and powerful corporations are just as accountable as any other Canadian. Additionally, there needs to be international cooperation and updates to legislation so those who try the hardest to avoid taxes end up paying their fair share anyway. Thank you for your time. Mr. Campbell and I would be pleased to answer your questions.
Thank you very much, Ms. Davio, and you've been here before, and I still got your name wrong. The lineup for the first round of questions will be Mr. Kelly, Mr. Fraser, Mr. St. Marie, and Mr. Julian on the 6-minute round. And to close off our witnesses will be from Transparency International Canada, Mr. Cohen, Executive Director. The floor is yours, sir.
Mr. Chairman and members of the committee, thank you for inviting me back to speak to you today. My name is James Cohen, and I am the Executive Director of Transparency International Canada. TI Canada is a registered charity and is the Canadian chapter of Transparency International, the world's leading anti-corruption movement. The release of the Panama Papers in 2016 was an explosive look into how the world's secrecy jurisdictions and an army of enablers hide illicit funds for crimes like tax evasion, corruption, and fraud. One revelation that came out of the trove of leaked documents is that Canada was happily being marketed as a secrecy jurisdiction by Mossack Fonseca, the firm at the heart of the Panama Papers. Toronto Star and CBC journalists found that Mossack Fonseca was marketing Canada to clients as a desirable place to store dirty cash based on our generally positive reputation, but importantly also our weak disclosure laws and enforcement. The correspondences the media published showing this advice were from 2012. TI Canada is currently re-examining this phenomenon of overseas and corporation agencies marketing Canada's opacity and finding that nothing has changed. The term that came out of the Panama Papers for money laundering and tax dodging in Canada, snowwashing, is alive and well. However, as of April 19th, Canada is in a better position. TI Canada and our civil society partners enthusiastically applaud the government's proposal to establish a publicly accessible registry of beneficial ownership in the 2021 budget. Canada has been slammed by international organizations, civil society, and peers for years, and now we have taken a large step out of that shadow. Of course, the federal government cannot establish corporate beneficial ownership transparency on its own and expect the problem to be resolved. The provinces and territories must come on board with this initiative. Thankfully, there is already momentum as we see Quebec on the cusp of making corporate beneficial ownership information public via Bill 78. And the British Columbia Land Ownership Transparency Registry went online last week. We hope this will be followed by a public corporate beneficial ownership registry too. The world is shrinking for tax dodgers, kleptocrats, and fraudsters to hide. In 2016, the United Kingdom was the first country to have a public beneficial ownership registry. The UK's overseas territories and crown dependencies, which include some of the most well-known secrecy jurisdictions like the Isle of Man, have also agreed to establish publicly accessible registries of beneficial ownership. In a joint statement, the crown dependencies cited their need to cooperate by 2023 with the European Union Anti-Money Laundering Directive 5, which requires all EU members to establish a public beneficial ownership registry. From this trend, we see that after years of being regarded as a laggard, Canada has the chance to move up to the head of the class on beneficial ownership transparency. While I would never say that any tool is a silver bullet for solving tax evasion and money laundering, a publicly accessible registry will be a powerful tool. It needs to be set up correctly, though. We can learn a lot from our peers in the UK and EU and make sure that our registry has verified data and harsh consequences for those trying to falsify information. Canada's register should also have a staff that can conduct proactive investigations and a tip line for people to provide information on suspected tax evaders so proper investigations can be conducted. This will be a big year for international forums to address beneficial ownership transparency, corruption, money laundering, and tax evasion. There will be the G7 hosted by the UK, the UN General Assembly Special Session on Corruption, the Open Government Partnership Summit in South Korea, and eventually the Summit of Democracies hosted by US President Biden. This year, the Financial Action Task Force, the global standard-setting body on anti-money laundering, will also review recommendations on beneficial ownership transparency, possibly making public registries a new standard. Canada now has a foot to stand on in these forums for calling for greater transparency from others in order to continue to close the space for tax evaders, kleptocrats, and crooks to hide. Thank you, and I'm happy to take any questions from the committee.
Thank you very much, Mr. Cohen. Just to say, the public registry was one of the key recommendations from this committee on our study on money laundering, which was, I think, one of the best studies that we've ever did. So we're glad to see that out there too. I forgot to mention, Ms. Debbie. Oh, yes, please send us that information to the clerk that you mentioned in terms of those reports. It'll be helpful to the committee. So we'll
I was going to mention to you, Ms. Treaser, it doesn't matter what you call me so long as you don't call me late for committee.
Okay. I'm awful at names and everybody knows it. We'll start with, on the 6-minute round, Mr. Kelly. Floor is yours.
Thank you, and thank you to all the witnesses. Great opening statements. I would like to. I'm going to start with Senator Down and start by thanking you, Senator, for your leadership on trying to shed some light onto the obvious ongoing problems that we have here in Canada with tax evasion and the lack of data. Good data that could help inform policymakers about that. Can you talk about? I mean, you had a private member's bill or a Senate bill that I was very proud to and pleased to sponsor in the House of Commons. It was defeated, but it would have compelled better disclosure and better measurement of this problem. Could you comment on the lack of good public information about the scope and scale of tax evasion and how that limits policymakers?
Yes, thank you very much for that question. What happened, of course, was other countries around the world were assessing their tax gap. And as you know, that's the difference between what your National Revenue Agency collects and what they actually should be collecting. So hence the gap. The second thing the tax gap analysis does, it indicates how effective and efficient your revenue agency actually is. In other words, how good a job they're doing. So the United Kingdom, Turkey, Switzerland, a whole host of countries, the United States, even the state of California measures their tax gap. They all find it a useful tool. I asked the parliamentary budget officer some years ago to do it. I didn't want the CRA doing it for a host of reasons that I'd be pleased to expand on if you're interested. I wanted an independent analysis done by the PBO. The parliamentary budget officer could not get the cooperation of the revenue agency, notwithstanding they had a legal opinion that entitled them to the information on a confidential basis. They're not interested in individual taxpayers. They're interested in the overall numbers. So that has not happened. We don't have an independent analysis. What we do have, under much public pressure, the Canada Revenue Agency started to do one-off tax gap analysis. For example, they did one on corporate dues. They did one on excise customs. They've done 6 in total. And by the Canadian revenue analysis, the tax gap is between $20 and $24 billion. There's a whole bunch of other tax gap analysis have to be done, and that's why the PBO should be doing them. So we have that overarching view. The other thing to remember of the tax gap, it's sort of like political polls. The numbers aren't as important as the trend line. So how much of this money is the CRA actually collecting, and is the gap getting greater or is it being reduced?
Yeah, that's a great point, and thank you for that. To what do you attribute the absolute, the complete failure to prosecute that you pointed out in the Panama Papers, the Paradise Papers, compared with other countries?
Well, that's the question, and there's been a number of analyses on why that has not happened, but it reflects very badly in Canada. 5 years later, where's the money? The CRA, when you're dealing with them, they're very careful to talk about how much money they have identified, how many audits they're conducting, but when you ask them about how much money they raised, have collected, the answers get extremely vague. In fact, there's no answers. So 900 Canadians and no money is the bottom line. If they had a lot of money collected other than identified, they'd be singing from the rooftops. So there's a serious problem at the CRA, and my view is after these years of looking at the revenue agency, and this is not a reflection of the employees of the CRA. As I said in my opening comments, they do an outstanding job on domestic tax evasion, but there's a lack of leadership, and I have drawn the conclusion that we have to have the Department of Finance overseeing them and giving instruction.
Have I got time for another question, Mr. Chair?
Yes, you got lots. Go ahead. You got 2 minutes.
Perfect. I'd like to get Ms. Davio into this then, because Senator Down mentioned it, and also you mentioned it in your opening statement. You talked about, actually made me direct reference to the Auditor General's report of 2018, I believe it was, where they talked about the fact that a domestic tax evader, or actually any tax filer that has a demand for documents or information, is only given a very short window before the taxes are automatically applied to them, and yet an offshore filer, a filer with international banking connections, can be given months or years to comply with an order for information and without any tax being applied. So you're aware of this. What possible reason could there be for this discrepancy?
I'm not sure. I'm going to turn it over to our economist, Ryan, who has delved more deeply, and perhaps he can give you some insight. But from my perspective on this question, Mr. Kelly, it's the problems are because there are gaps in legislation that even when people are prosecuted, were unsuccessful because of the decision of the Supreme Court finds holes within the existing legislation. So legislation
we're talking about an order for documents and being given extra time just because you're overseas.
I'm not sure.
I have asked this question at committee before and been told usually it's, well, these files are more complicated. So I would like, if your colleague can give an answer to that's maybe better than the ones that we've heard at previous committee would be great. Go ahead.
Sure. Well, let's give him a crack at it anyway.
Mr. Campbell, the pressure is on you, sir.
Yeah, I mean, I think Debbie provided a good answer, and just reiterate that we're here as a representative of the auditors. We're not here as a representative of the Canada Revenue Agency itself. So I think it would be better to have
that's a fantastic point. I would love to get, and hopefully we'll have the minister here on this study at some point, which the minister should answer that question. But it would seem to me that complexity shouldn't enter into it. If you ask for a document, if your corporate structure is too complicated to comply, then that should be on the filer.
Mr. Kelly, we used to have international tax units that were very well organized and could work together more effectively to produce those kinds of documents, but those units were broken down some 10 or so years ago in favor of putting interspersing these tax experts within more generalized teams, and that has reduced the capacity of employees at the CRA to be able to deliver on on, getting international tax avoiders to pay their fair share.
We are well over time on that one. Maybe if you could send us a little note on when that international tax units were cut out of the system. Mr. Fraser, 6 minutes.
Thank you very much, Mr. Chair. And before I get to my questions, I want to begin by thanking Ms. Watson for being with us today. Her story is a powerful one, and I believe the word she used was that she wanted to remind us that this is not a victimless crime. Although there's certain individuals who are impacted very directly, I would argue that the class of victims is almost limitless when comes to tax evasion. Anybody who hasn't got a family doctor, can't afford to pay for school, or suffers from a lack of access to services is a victim of those who choose to evade paying taxes that they properly owe. And the quality of life that we all enjoy is diminished as a result. My first question is for Mr. Cohen. You spoke with some enthusiasm about the announcement to establish a registry for beneficial ownership. This is a useful in this audience of people who study the budget, but I'm curious if you can put into plain language for Canadians who may be watching the importance of having a publicly accessible registry so folks know who's behind some of these shell corporations or organizations that might be used to hide the beneficial owner that might be benefiting from those who evade taxes.
Right, thank you for that question, Mr. Fraser. As you say, it's a publicly accessible beneficial ownership registry to identify the true individual. So you have, for anybody not familiar with beneficial ownership registry and shell companies, company ABC owned by company 123, owned by company Ontario 456, opened by Bob. Who's Bob at the end of the day? And why the level of secrecy? And Bob could be an entirely legitimate business person, but there is no there's no precedent for anonymity behind all those layers. Bob could also be somebody who is evading taxes, denying Canadians revenue for the very services that you discussed in health services or the environment, or a kleptocrat from overseas stealing money from some of the most vulnerable people around the world, hiding it here in Canada. That individual could also be criminals that are perpetuating the fentanyl crisis in Canada and facilitating gang activity. It could be a sanction buster trying to move money around to allow weapons to go into countries like Syria. So there's a whole host of number of people. And as Ms. Watson alluded to, this is not victimless. When we talk about these grand numbers that are being moved around through the shell companies, there's a precedent crime underneath these, and whether it's undermining Canadian society through sapping resources to fund our public services, or allowing criminals to continue to operate within Canada for crime in Canada or overseas, or ruining our good name abroad while we give foreign aid money, but having stolen money from those very same countries wind up back in mansions in Montreal or Toronto or Vancouver. This all has an impact, and it all should matter to everyday Canadians.
Thank you very much, Mr. Cohen. I'll use some of the examples you discussed, particularly in the global context of this problem, for my next question to Ms. Davio. Ms. Davio, you mentioned that one of the things that we continue to need to do was to explore further initiatives on the international stage and cooperate with our global partners to ensure that we can stamp out tax evasion globally. What actions can the federal government in Canada take to help contribute to the global solution to the issue of tax evasion?
I'm going to ask Ryan to take that on.
Hello, everyone. Yes, so I mean, the biggest issue that has been advocated by our by auditors at the Canada Revenue Agency is to, based on their work, is to focus on corporate tax evasion. The scale is much larger. The PBO has identified, as much as $25 billion a year could be accessible or unlocked from tax havens if the right provisions were in place. And in order to do that, it's really necessary to kind of reorient the way the tax system is structured, and reform the current state, which, now an international corporation, they make a sale, they have some discretion to, transfer the profit or modify the price within internal supply chains to book the value of that sale in a low tax jurisdiction. And from the standpoint of CRA auditors, it's a game of cat and mouse to try to, figure out exactly how, and what the fair market value of that transaction was, and determine whether or not it was on the level. And so, in order to tip the scales back in favor of companies being taxed fairly everywhere, there's a specific kind of combination of different reforms that can be put in place, or kind of broad principles, a combination of which would solve the problem. One being a formulary allocation of profits, which is basically a kind of a change in criteria that is currently in use in Canada that determines how a corporation's profits are booked from province to province. The other is unitary treatment to make sure that that these transactions that happen between a parent company and a subsidiary that lead to this transfer pricing and then profits being booked in low tax jurisdictions, and instead of where the commerce actually happens, so that globally corporations are treated as a unitary entity. And
Mr. Chair, I think I'm very near the end of my time. Have I got a chance to squeeze one more specific question along these lines in for Mr. Campbell? You're on mute, but I sense you're saying if I'm quick, I can go.
All right.
Yeah. Thank you. Well, Mr. Campbell, look, there seems to be, from the testimony we heard today, quite a few different measures we can implement. Most folks I've spoken with about the issue of tax evasion have argued that the return on investment, if we pour money into enforcement, is well worth it. If you could highlight one or two key areas where we would see the greatest return on investment in terms of money we can put towards enforcement, where is that? And I noticed Ms. Davio actually unmuted herself, so I might give her the floor if she wants to give an answer.
Yeah, if that's okay. I mean, I certainly turn over to Ryan on the very technical stuff, but what we're hearing from our members, I had mentioned very briefly that, there had been some organizational changes that were not helpful. For example, criminal investigation units, were amalgamated, and now there's no criminal investigation between Calgary and Toronto. It's more of a domestic problem, but you really do have to look at the physical presence of resources in different regions, and also the international tax units. How do you leverage the best expertise of your international tax experts? How do you resource them properly, give them the proper training and the proper technology that they need to go up against, tax giants that they're having to work against? And so, it's that simple question of, invest $1 and get $5 back. It might even be higher, but certainly that one's got some facts and evidence behind it. It just makes sense that you want to properly resource your people at the Canada Revenue Agency so that they can actually combat some of this. And that doesn't require, big changes. It just requires an investment in people.
We are going to have to end it there. Sorry, Ms. Davio. Right. We'll turn to Mr. St. Marie, followed by Mr. Julian. Gabriel?
Oui, merci, Monsieur le Président.
Thank you. And thank you to all the witnesses. Thank you for your presentations and your presence here today. Mrs. Watson, your testimony was very striking, and let's hope that justice will be carried out. And thank you. Thank you. And hello, Elizabeth May. And M69 is being presented in the House, and this reprises the measures that have been suggested by the witnesses with regards to tax evasion. My questions are for KPMG. Mrs. Iacovelli, I'm asking you and KPMG Canada to provide the Committee of Finance the following information. KPMG implemented fiscal stratagems with regards to a financial vehicle allowing some clients to reduce their tax bill. If KPMG created shell companies in the Isle of Man, allowing one or more taxpayers to hide funds or to reduce their tax to be paid, to provide to the committee all documents used during this planning, to provide the list of companies that were created, to provide the list of directors and administrators linked to this, to provide a list of everyone who benefited directly or indirectly, and to provide us the honoraria collected by KPMG for this tax avoidance and asset protection structure. Could you provide this information for each of these structures that used other jurisdictions other than the Isle of Man, and mentioning the jurisdiction for each of these tax planning schemes? The clerk will be able to send this request, and if you're not able to answer right now and provide this information, I would ask you to send this in a written form at the Committee of Finance as quickly as possible within a period of 30 days. Did you take note of this? So I'm going to continue.
Miss Lacavelli a chance to respond first, Gabriel. Miss Lacavelli.
Thank you. That was quite a comprehensive question, so I approach everything.
Ça, c'était une question très complète. Alors, je vais essayer d'y réagir.
With this. So I want to be clear that KPMG did not set up shell companies to hide money, and that's not what we do. We do we provide legal advice that's tax effective, and we require that our clients meet all their filing obligations. With respect to your request in terms of providing information, under my code of conduct, I'm not able to provide you with client information unless there's a legal order that's provided. We have dealt with the CRA's request, and we have provided the CRA with the list of all of the OCS clients and a list, and provided the CRA with all of the OCS files as well.
Gabriel.
Oui, je vous remercie pour votre réponse. Il y a peut-être
Thank you for your answer. Maybe there was a problem with regards to interpretation. I didn't say that KPMG had implemented schemes that were determined to be illegal. That is not what this is about. And so, to my knowledge, KPMG, an accounting business, cannot refuse to provide this information to a parliamentary committee here in Ottawa. So, as I was saying, to be sure that we're clear, the clerk will be able to send you the request that I've just made, and then you can come back to us within 30 days. Same thing, I would ask you to, for each of the KPMG clients, the conclusion reached by CRA Canada, including the tax reimbursed, interest incurred, and penalties as well for each person. Thank you.
Do I have an opportunity to respond?
Yes, you do. Go ahead. Floor is yours.
Okay. I just want to point out that under my professional code of conduct, I'm not able to provide any details with respect to clients or former clients. Again, if there's a court order, legal order provided, I could provide that information. We've provided all of the information with respect to the offshore structure to the CRA along with files.
What I would suggest there, Gabriel, if I could, is if the clerk can send you that information, Ms. Lacavelli, then you can respond in kind, and we'll see where we're at. I'll not take that time from you, Mr. St. Marie. You still have about a minute and a half.
Oui, merci, Monsieur le Président. Donc, très bien.
Thank you. And so our reading of the law is a different interpretation. Mrs. Iacovelli, did KPMG Canada ask another business, for example, KPMG at Isle de Man or another company, to create directly or indirectly one or more of the 4 businesses registered in the Isle of Man under the names of Qatar, Siak, Spata, and Chasqua?
the four companies that you've mentioned, which are known as the sword companies, are not KPMG clients. We have never been involved in those clients, and we have not set those clients up.
Je repose ma question. C'était pas exactement ça.
That wasn't exactly my question. Did KPMG ask another business to create, directly or indirectly, the sword companies? Did KPMG Canada contribute or participate, directly or indirectly, or use directly or indirectly, one or several of its four businesses? And if so, how?
Ms. Lacavelli.
We did not participate directly or indirectly. We did not ask another firm to set up these companies. We have no relationships, whether directly or indirectly, with the sword companies.
Okay, thank you. Thank you both. We'll turn to Mr. Julian and Mr. Falk. You'll be next in the 5-minute round. Peter?
Thank you very much, Mr. Chair. Thanks to all our witnesses for being here. It's ironic, Canadians were asked last week to file their income taxes in the midst of a pandemic, and Canadians are paying their income taxes, and we're now talking about tens of billions of dollars that is simply being taken overseas and is not subject to that common good, that collective investment that advances Canadians. So I appreciate all of you coming here today. I'd like to start with Ms. Watson. Thank you very much for your very important testimony today. I just want to reiterate and ask you that as you were doing all of your due diligence, as you did all your work to try to get back the money after the fraud, you were told by every government agency or representatives, including the RCMP, that there was no way to get that money back once it left the country and went to an overseas tax haven. Is that correct?
Yes, that's correct. We were told, I mean, some of our members, our victims who lost, including Mrs. McDonald, who appeared on the Fifth Estate with me, they lost $500,000. I mean, she's doesn't mind me saying so. She's stated that publicly. They went to the Ombudsman. They went to the AMF, the Provincial Securities Commission. They went to the police. They went to the RCMP, and they were told the same thing. You know, you may as well forget it. It's gone. There's no way to trace it. And especially Raymond Chabot Grant Thornton, I was one of the bankruptcy inspectors working on the file. And in all our meetings, you know, they just said, we'll recover what we can, but there's no way to recover it once it's left the country, especially if there's no agreement with these other countries. So I thought the money was probably in the Bahamas or someplace like that, but now I suspect some of it may have gone to the Isle of Man.
So may I, just as a follow-up, you come to committee today, what would be your message and the message of all of the other victims of this fraud? What should the government be doing so that you could no longer defraud Canadians and just take the money to an overseas tax haven?
Well, they should obviously tighten up our laws. The Canada Revenue should be able to trace this money. I mean, the police can't do anything more. I think it's a political issue now. I think it's something that the government has to deal with. You know, Canada Revenue went after, I think I mentioned we recovered some money in a class action suit where we sued some of the accounting firms. And when the money came back to us, obviously some of it was in registered RSPs and RIFs. Some of it was, investments outside. And Canada Revenue just made us jump through all sorts of hoops because they thought people would lie and say that their money, that they'd already paid tax on the money, and that because we had the option of putting the money back into RSP. I mean, they made us jump through hoops to do that. So, you know, and yet these people these rich people get, you know, these tax breaks all over the world. So.
Thank you very much. I'm going to move on to Ms. Iacovelli. And as Mr. St. Marie has mentioned, when a committee requests information, it's important to follow that request. As you know, there's a non-cooperative tax jurisdiction list, which basically lists tax havens around the world. I have a series of questions as well. We'll be following up with a letter that we'd like KPMG to answer. First off, how many, you called them client companies or shell companies, how many client companies currently exist in the Isle of Man and in all of the other jurisdictions that are non-cooperative tax jurisdictions that KPMG has set up? That's my first question. My second is, how many were established since 1999? Again, in the same list to the KPMG internationally. How many have been dissolved or wound up since 1999? That's my third question. My fourth question, how many Canadian clients of KPMG invest in overseas tax havens, either offshore bank accounts or shell? You've called them client companies. And how many out-of-court settlements has KPMG negotiated on behalf of those clients with Revenue Canada? Those are the questions that we will ask you to follow up on. I also note that you are here voluntarily. We certainly appreciate that. We will be convening, I believe, other witnesses from KPMG, including Serge Bellido, who runs your Montreal office, and we appreciate that cooperation. Can you also indicate when you receive a notice to preserve documents, how those notices are observed within KPMG internationally? And my final question is around the Parrhesia, which you've have acknowledged is a KPMG client company, incorporated the same date as the Sword companies on December 17, 2001. First, you said in your testimony that that it was a common registrar that that KPMG had approached. Then you said that nobody was engaged to actually incorporate Parrhesia. Could you clarify that, please? Who within KPMG actually moved to register that client company?
A lot of questions there, Ms. Lacavelli. I think some of them will come in written form. So on the general one at the last, could you respond?
So with respect to, maybe I'll start with the question with respect to products. We don't offer products. We offered the OCS product until 2003. We stopped offering the product in 2003, and we have not offered products since 2003. With respect to, I think you also asked a question with respect to tax havens. We don't provide any tax schemes or shelters with respect to clients. It's not what we do. We provide legal tax planning with respect to our clients and we ensure that our clients pay the taxes that are required. Unfortunately, I can't speak to Parrhesia. I'm not familiar with that, and so I will have to undertake to provide that if I can. I appreciate if you could appreciate if it is a client, I can't provide information with respect to client files.
Okay, thank you both, and we'll come back to Mr. Julian in a later round. Mr. Falk, followed by Ms. Katrakis. 5-minute rounds, Ted.
Thank you, Mr. Chair, and thank you to all the witnesses here at committee today. Your testimony has been very interesting and intriguing, and I wish I had lots of time to ask you all questions because I do. Senator Down, I just want to make a mention because I don't want it to be lost and I want it to be recorded, that you provided testimony that many of the other countries involved with offshore tax schemes have been able to recover funds and Canada has not. And I find that very intriguing. But Ms. Watson, I would like to ask you questions. You and Ms. McDonald participated with the Fifth Estate, and I've found that episode very intriguing. And my question on that, you've done 14 years of relentless pursuit of justice and digging and trying to recover and acting on behalf of many of the individuals that lost money through this tax scheme, Manivile. I'm wondering, would you be willing to comment on whether the Fifth Estate broadcast accurately reflects the research that you've done?
Yes, I would definitely say it accurately reflects the research I have done. I worked with them during the producing of the program, and they went way beyond. They uncovered things that I had no knowledge of. I'm a 74-year-old housewife living in the Eastern Townships. I do not have the resources that they do to do this kind of investigative reporting, and I was really very intrigued. I didn't know until I watched the show exactly what they had uncovered in the Isle of Man. And it was an eye-opener. But, I mean, it was something we always suspected because the money just disappeared. I'm not talking just about Mount Real. I'm also talking about North Shield and Sinar. The three companies were linked, and there was $500 million. So it didn't just disappear. And I believe that KPMG was actually the accounting firm for one of the North Shield companies. Ms. Iacovelli keeps mentioning Sinar, but I believe they were also one of the an accounting firm for one of the North Shield companies.
Okay, so, thank you, and my sympathies to you and to all the other victims of that fraud.
Thank you very much.
And with that, I would like to switch over to KPMG, Ms. Iacovelli. You've indicated you weren't involved as a company, and that you didn't provide advice to your clients on how to develop any of these schemes. Have any of your clients or your organization been involved in the Liechtenstein scheme?
Unfortunately, I'm not aware of any.
Okay, and the Panama Papers scheme?
My understanding is that the listings and with regards to the Panama Papers are not publicly available. So I'm not aware that any of our clients are within those Panama Papers.
Okay. When this committee was discussing concerns about tax avoidance and evasion with KPMG in 2016, Gregory Wiebe was asked about whether the Isle of Man scheme helped to restore the trust of Canadians in the tax system. And he had this to say, and I'll quote, "I think that if you look at that particular issue through the lens that we look through today, no. I think that if you look at that issue through the lens that existed at the time, in 1999, when it was policy and practice for individuals to have monies in non-resident structure offshore, it was a very different time. We used to smoke in restaurants in 2006. We used to text in our cars up until 2 years ago. Times change and we changed with them. Looking at it through that lens, I can't defend it." So my question to you, Mrs. Iacovelli, would be is how would you say that KPMG has changed since 2016 when that testimony was provided?
I think that we had, I think, already changed by 2016. We operate under our global and national code of conduct, which is our responsible tax practice. Some of the highlights from that responsible code of conduct are that we act lawfully and with integrity, and that we provide clients with the highest quality of tax advice. When we look at the lens from 20 years ago, the lens that we looked at was legality, and it was looking at GAR. Since then, and since the mid-2000s, we've added the additional lens of responsible tax. And so the economy, the tax landscape and social acceptances has changed greatly over the last 20 years. You could see it through also a great deal of legislation that's been put in place with respect to not just in Canada, but globally as well, including Sarbanes-Oxley, the FIN 48 legislations. There was the global financial crisis, which impacted this greatly. There is the common standards reporting that was introduced as well. So there's been quite a bit that's changed with respect to transparency, which has very much changed the social landscape and what's acceptable.
Okay, thank you.
I'm sorry, we're going to have to move on. We are over already.
Thanks.
Ms. Koutrakis, followed by Mr. St. Marie. Ms. Koutrakis.
Thank you, Mr. Chair, and welcome to all our witnesses this afternoon. I'm Ms. Watson. I don't know if my colleagues know, but and I say to you, I was very disturbed to listen to your testimony because I've been employed in the financial services industry for more than 25 years. I started in 1984 as an assistant stockbroker and went all the way up into a leadership role on the retail side, working for large firms owned by big banks and independent firms. So I was employed in the industry in 2005. And when the story broke out on Mount Real, North Shields, and Sinar, I have to tell you, I was supervising at the time portfolio managers and financial advisors. And one of the primary roles and responsibilities that I had as a registrant, a professional registrant with IROC, was to make sure that the people that I was supervising were doing the right things. And doing the right things meant when new accounts were brought on my desk to be reviewed and opened, I had to make sure that I knew who that account belonged to. It was removing the corporate veil. So when I listened to the testimony today saying that, you know, we don't have a public registry to show who the owners are of some of these shell companies, I can tell you that through IROC, we were doing that. So perhaps, you know, we can, you know, work directly with IROC and the Autorité des marchés financiers in Quebec as a starting point. My first question is to KPMG, Ms. Iacovelli. And I know in your testimony you said that, you know, you don't advise your clients, wealthy or any kinds of clients, to get into tax avoidance schemes. But I look to you for guidance and professional, I guess, what kinds of checks and balances are in place for companies like KPMG when people approach you for tax information to make sure that we are not crossing the line or going beyond the spirit of the law? Are there any checks and balances when you are giving that type of advice to clients?
I expect that all of my partners abide by our code of conduct with respect to our responsible tax. Again, we provide legal tax advice. We act with lawful and we act lawfully and with integrity. And I expect that of all of my partners. You know, we explain clearly and objectively the technical merits and sustainability of tax advice to our clients. And we also don't allow for any transactions that are contrary to any relevant legislation. We also have a very robust mechanism of client acceptances to ensure that we're working with the highest of integrity of clients as well. And we've also got processes in place that if there is a transaction that's out of the ordinary, that it's brought forward to our Risk and Reputation Committee, which is made up of several partners, and it undergoes a GAR committee review ahead of that. So I'm quite proud of our organization, quite proud of the type of law that and the type of planning that we provide to clients.
Thank you. My next question is to Senator Down. Senator Down, you said in your testimony that the CRA has done a really great job on the domestic tax evasion side, but you've been critical of the agency's ability to address overseas tax evasion. What tools or powers does the CRA need to effectively address foreign tax evasion to the same extent as domestic tax evasion?
Thank you for that question. Actually, what I indicated in my opening statement as well was a suggestion on compensation. Some of the people at the CRA are really what I would call unicorns. They have unique skill sets that they have developed over 10 or 15 years working for the government of Canada, but they bump up against a salary cap that is government-wide. And we have to address that. We have to be able to retain these people so they're not scooped up by those who are working, if you will, on the dark side of tax evasion. You can't blame people for wanting to improve their financial situation personally, but the government has to take some initiative to keep these people. The second area is, others have covered it as well. Some of these international tax units have either been merged with other responsibilities or totally disbanded. So we need a dedicated group. We're not reinventing the wheel here. The CRA tells us how complex it is on these cases, but it's complex for every country. But as I indicated, Iceland, with 340,000 people, recovered $25 million in the Panama Papers. We have not recovered anywhere near that, if anything. So there's something wrong there with the structure of the CRA, and the senior management and/or the finance department should address it.
Okay, I'm sorry. We will have to move on, Annie. We're over on you too. We'll go to Mr. St. Marie, followed by Mr. Julian, 2.5 minutes each, and then on to Ms. Jansen.
Oui, merci, Monsieur le Président.
Thank you. Mrs. Watson, I would like to tell you that we're going to do everything we can to get to the heart of this. We are not going to give up, and you can count on us. Regardless the time that it will take, we're not going to give up. Thank you. Now, Mrs. Iacovelli, I am extremely disappointed with your answers. Peter Julian asked you questions, and now you're saying that you have nothing in the Panama Papers because the list doesn't exist. It was disclosed by the consortium of journalists. You're being obstructionist, and the way that you're behaving in this committee makes it so that I have difficulty in believing you. Mrs. Watson said you had companies and they stole money, and all of a sudden this money disappears, and you're telling us that KPMG has no direct or indirect link to all this money that disappeared when articles by CBC and Radio-Canada revealed that, one, some of these companies were created during a single day. I don't believe you. I don't believe you at all when you say that you're not involved. And we're going to send you the questions that you have to answer to, and your ethics code to say, "Oh no, we're not answering." That is not the act. That is not the act at all. What you're saying. And so I hope that we will receive answers to our questions. Also, Mrs. Iacovelli, you said that everything we do is legal. Yes. Why? Because you're in Canada. In the U.S., when KPMG did the same thing, well, the equivalent of the CRA, the IRS, laid criminal charges against KPMG and threatened KPMG to say that it would have been a criminal organization that led to this. In the U.S., this is what happened, and change occurred. People paid penalties, reimbursed people. KPMG to not be dismantled, did dismantle 3 of its divisions, said they wouldn't sell any of this planning, paid damages of $5 million, and gives unlimited access to its files to the IRS. And so that is what we should be doing here, to go to the heart of this. Criminal charges were laid against 9 directors. 6 had to pay fines up to $25 million, and 1 was jailed. And this is what we should do here if the CRA had.
Maria, you're at the end of your time, but I will give Ms. Iacovelli equal time to respond. Go ahead, Ms. Iacovelli. Floor is yours. You're muted, Ms. Iacovelli.
Thank you, Mr. Chair. We have no connection to CINAR. We are not involved with CINAR. We have never provided audit or tax advice to CINAR. We are not connected in any way.
de Montréal.
Just Gabriel, give Ms. Iacovelli's got the floor, and I think you have a previous note from her as well. Ms. Iacovelli, go ahead.
Thank you. We are not in any way connected to the Ford Sword companies. We have not ever provided any advice with respect to those companies, and we are in no way connected to those companies. We have cooperated fully. We've cooperated fully with the CRA. We've provided all of the files with respect to our offshore structures. We've provided all the client names with respect to the offshore structures.
Okay, then we'll move on to Mr. Julian. 2.5 minutes, roughly, Peter.
Merci, Monsieur le Président. Moi aussi, je suis
Thank you. I am also very disappointed with the type of responses we're receiving from KPMG. There are some questions that we are asking, and these questions remain unanswered, and the Finance Committee does have the authority to obtain this information. It is not a case where KPMG can say we had absolutely nothing to do with this. To answer questions, explanations have to be provided. We have not received any answers to our questions, and many, many questions have been asked before this Finance Committee.
Pointed by the quality of the answers that we're getting. I want to come back to the issue of client companies or shell companies. En français, on dirait des compagnies bidons. You said that there are no longer any shell companies or client companies as part of KPMG's strategy. Did I understand correctly? And could you give us the date when those companies were dissolved or wound up?
Thank you, Mr. Julian. In terms of specific client information, I can't provide you with the details. My code of conduct precludes me.
Excuse me, I'm not asking specifically. I'm saying I asked the question earlier, how many companies have been dissolved? You said that they've all been dissolved, and I'd like to know the dates when those companies were dissolved. That's data. It's not privileged information.
Mr. Julian, I did not indicate that. I didn't mention anything with respect to clients. I didn't indicate whether they were resolved or not. I cannot discuss client information with respect to this committee.
Point d'ordre, Monsieur le Président. En vertu des...
Point of order. With regards to the powers given to this committee, this act has a precedence. It's not an argument that can be brought before the Finance Committee. I'm sorry about that.
I asked you.
Okay, just let's back up a little here. I heard your point of order, Mr. Julian. You made your point, Gabriel. Mr. Julian, you have about a minute left.
My question was very simple. How many client or shell companies exist? You said that we do not use this anymore. Does that mean that you have dissolved all of these shell companies or client companies, including Plantation Island, General Island, Sandy Point, First Land, Parhesnia that I mentioned earlier? Does that mean that those companies no longer exist, or does KPMG still have shell or client companies as part of its portfolio?
Ms. Lacavelli.
We do not offer the product. We have not offered the product since 2003. With respect to the specific client information, I cannot provide that information. CRA has the names of all the clients, and we've provided them with each of the client files.
Ms. Lacavelli, I'm not asking for privileged information. I'm asking for numbers, and you have access to those numbers. I don't understand why you are not being cooperative and answering these questions. They're legitimate questions.
Mr. Julian, I believe that my colleague Greg Weeb, when he was at the Finance Committee previously, indicated that we stopped offering the product in 2013 and that there were 16 implementations of that product.
Okay. We are going to have to go to the next round, which will be Ms. Jansen, and I think you do understand, Ms. Lacavelli, there will be some written questions coming your way. Ms. Jansen, we're into 5-minute rounds, followed by Ms. Zerowitz.
Thank you. Mr. Cohen, how could transparency assist in the fight against tax avoidance and money laundering in our country? I understand there are legal loopholes which allow for some entities to accept large overseas transfers without reporting them to FINTRAC, such as lawyers who talk about lawyer-client privilege. Some say they're the worst offenders. Would the beneficial ownership registry tackle that problem in any way?
Thank you for that question, Ms. Jansen. Yes, the publicly accessible registry would do a lot to fight tax evasion and money laundering in a number of ways. Currently, only financial institutions are required to do beneficial ownership due diligence by the Proceeds of Crime, Money Laundering, Terrorist Financing Act. Thankfully, we are seeing the amendments go into force in June, where all designated non-financial businesses and professions need to do the same due diligence. So that will include accounting agencies, money service businesses, real estate agents. And legal professionals do have to do that due diligence. Due to the Supreme Court ruling, they do not need to file suspicious transaction reports. But it does put a lot of pressure on all the professions to conduct the due diligence and now have the data. They can't say, well, I've tried with a client, I don't know. So once we have the registry in place, it's very important that that data be verified through various methods so that all the various bodies who need to report and even people looking to invest like Ms. Watson have the ability to do their own due diligence as well. So in a lot of ways, this will deter those bad actors from first coming in the first place. And hopefully those who still want to game the system will be caught.
Okay, thank you very much. Now, Ms. Davio, you mentioned how CRA was criticized in the previous decade for focusing audits on small businesses and charities and how that impacted auditing work. You also mentioned in your testimony that the focus should be on wealthy individuals and powerful corporations who do the majority of the cheating. Is there a justification for the fact that CRA appears to be aggressively focusing on small mom and pop shops for audits during COVID and ignoring the wealthy individuals and powerful corps you just identified as the real problem?
Yeah, I actually don't think they're ignoring them. I just don't think they have the same capacity to address international taxes that they do to address local taxes. And, you know, I don't want to reiterate what those drawbacks are again, but, you know, certainly employees at the Canada Revenue Agency are up against, as I said, tax giants. I mean, these are people who have immense skill, technology, you know, expertise, and other big companies on their side. And so they need to be able to be on a level playing field.
Okay, so what I understand from what you're saying then is that domestic audits are much easier to chase than an international one. Now, I understood from your testimony just now that there was a lack of expertise among the team of auditors when it comes to international audits. Does that lack push auditors to work mainly on those less complicated cases, which would generally have cooperative business owners who are very easy to contact and follow up with?
Yeah, there's actually no lack of expertise, but rather capacity in terms of organizational structure. So what I talked about was they had broken down international tax units that really took away their ability to realize synergy of working together and exchange of documents and information. These are very complex files, and they need to be set up a certain way and resourced to be able to attack them. And so those resources are now part of generalized teams, and they just don't have the right tools to address it.
Right. So it doesn't. You're saying capacity. You don't have enough people. So instead, you're going for the easy targets, which is really distressing to me. But sorry, I just want to qualify. I'm not saying that at all. I'm saying that international tax resources are focused on international taxes. There's no crossover. They're not asked to work on local files instead. Thank you. Sorry, I have a short amount of time, and I have another question.
But we will, Tamara, you get the time. We'll let Ms. Davio finish your response, and then we'll go back to you.
No, that's quite all right. I think I said what needs to be said.
Ms. Jansen.
So back to Mr. Cohen. Wouldn't the problem with tax avoidance be somewhat improved if we finally committed to cleaning up the cumbersome tax code, which is made worse year after year with boutique tax cuts and loopholes? I know that this year's budget was full of all sorts of technicalities that the officials took endless hours to explain to us over the last few days. I saw Mr. Easter there and Mr. Fraser. I can't even imagine the amount of work tax accountants spend every year just to get up to speed on all the changes. Wouldn't the KISS principle be a good place to start with our tax code?
Thank you for the question. I wouldn't be able to answer that from a TI Canada perspective. I'm not an expert in the tax code. As an individual, I'd be happy for a simple tax code. But I mean, the less loopholes, the easier. And just to make that distinction between tax avoidance and using legal means and tax evasion of not declaring anything, period. That would be my only answer to that.
Okay, we are going to have to end it there, and we have recommended a comprehensive review of the taxation system from this committee, I believe twice over the last 6 years. Turning to Ms. Zerwitz, followed by Ed Fast. Julie?
Thanks so much, Mr. Chair. My first question, so first, thanks to everyone for their excellent testimony and this important conversation. Ms. Devio, my first question is to you. You started off by saying that you represent, all the workers who work for the CRA, and I know that you work very hard. You were talking about how they have a hard time with, they're noticing people sort of take advantage of loopholes and exemptions and tax credits. My question to you is there some sort of a process whereby there are actually some feedback that actually comes from employees through to sort of senior leaders so that it gets to sort of government decision makers, so that we could sometimes there's like inadvertent things that happen and you kind of want to make those corrections. Are those things in place right now to your happiness and to the sufficiency that's needed so that we can maybe make some of those corrections sort of sooner than later?
Well, I certainly can't speak for the Canada Revenue Agency, although I personally don't know of any of such mechanisms that allow, sort of the ground level workers to feed up on some of those issues. I mean, recently there was a huge failure in the courts, Supreme Court on the Cameco case, and again, going back to those that were involved in that case, there are legislative loopholes, and nothing for them to do about that. Sorry, I completely lost my train of thought, Julie. But our auditors are telling us that they are simply lacking on particular resources, that they could do this job if those gaps were closed. And I'm sorry if I'm not answering your question, because as I say, I kind of lost my train of thought. We're very passionate about this because we do have mechanisms for our members to feed up to us. And we're hearing from them on a regular basis. We've conducted surveys, a number of surveys, some of which we've referenced during this testimony. And what our members are telling us is that there are gaps that need to be addressed. And we're using this forum, as well as any other forum we can have a voice in, to ensure that their voices are heard, by the decision makers.
Thank you. Well, I think that's maybe one of the areas we could look into, just because I always think that the people who are doing the work, it's good to find mechanisms to get feedback directly. My next question
I did reference the whistleblower stuff. You need the ability for employees to be able to blow the whistle on bad practices, and unfortunately, the protections for them are very bad right now, and so employees would not be compelled to do that.
Okay. And then I don't know who I should direct this to, maybe to Mr. Cohen or even Senator Down. I know we've spent a significant amount of money to try to sort of deal with tax evasion. And it's not necessarily, my sense has been, it's been, to try to deal with some of the, like a lot of the international tax evasion. So I think it was $444 million in 2016. I know it was $523.9 million in budget 2017. I know that in our fall economic statement, we invested another $606 million over 5 years to close the high net worth compliance gap, to strengthen technical support for high risk audits, to enhance the criminal investigations program. Has not any of that been helpful to actually sort of deal with the tax evasion issues, both, I guess, primarily internationally that we've been talking about? Mr.
If I
Cohen,
could answer that,
sure.
Chair. Of course, you made the key point there. It's over 5 years. And when I asked for documentation of how the money was spent, for example, in 2019, I received a written question in the Senate, and the government acknowledged that just over $250 million was actually spent from the 2016-17 budget. And then we found that where the money was spent was not quite where it was said it was going to be. The CRA advised us that they had to spend some of the money on funding towards employees' benefit plans. Obviously, treating your employees and fulfilling collective agreements is important, but it's not the same as cracking down on tax evasion, which was how the commitment was described in the budget. I don't have any additional information on the money, although I do note that the revenue minister stated in response to a House of Commons question number 541 that in order to free up CRA resources for pandemic-related programs, many audits have been temporarily suspended as a non-critical service. Wondering what that means about overseas tax evasion. All that's to say, it goes back to the point I was making earlier. There's something structurally and governance wrong with the CRA and how they run their operation. That's an area that should be looked at.
Thank you.
Thank you. Thank you all for that. Oops, I lost. There you go. I lost just for a minute. So we'll go to Mr. Fast, followed by Mr. Fragiskatis, and we will have. There's a little confusion over times, I think, from committee members. I got some notes. This session, we'll give it the full 2 hours, so that will make it 5:30 Ottawa, 5:33 Ottawa time we stop, and then we will go to committee business for a half hour. So we'll go to Mr. Fast, then Mr. Fragiskatis.
Point of order.
And then we'll pull in, yes, what's your point of order?
Point of order, Mr. Chair. The committee hasn't decided to shift to that we still have a lot of questions.
Well, that is what I'm saying we're going to, and that's what's in the agenda, and that's what we're going to. So we can debate that later. We can take more time and debate it here right now. We do have some other issues that we have to deal with as a committee, and the Budget Implementation Act is pretty important too. So we'll go to Mr. Fast, Mr. Fragiskatis, and then we'll come back to Mr. Kelly if that's where you want to go. Mr. Fast.
Thank you, Mr. Chair. And I'm going to direct most of my questions to Ms. Iacobelli, but first to Ms. Watson. My sympathies to you and all of the victims of these frauds. I wish there was a better way of recovering the losses that you've suffered. Now, you've heard Ms. Iacobelli say that KPMG had no culpability in the different frauds that we're discussing today, whether it's North Shield or Sinar or Montreal. Do you accept her denial?
No.
Can you tell me why?
Well, just judging by what was uncovered in Enquête and the Fifth Estate, there was too many coincidences. Ms. Iacobelli keeps referring to not being involved with Sinar, but I know KPMG was involved with North Shield. I'm not satisfied with her answers.
Okay.
I will give her the benefit of the doubt to say possibly she is correct, or maybe she's not permitted to give more information. That's probably the case.
All right. I'm going to ask some questions of Ms. Iacobelli.
Okay.
Ms. Iacobelli, you have denied any culpability in these frauds, but you did acknowledge that KPMG has established offshore structures for clients, correct? Just yes or no?
So we provided products, which was the offshore product, until 2003. We have not provided any products after 2003.
But prior to 2003, this product you provide, are you referring to the OCS program?
The OCS structure, correct.
All right. So, and just for complete clarity, when you're referring to that product in these offshore structures, the purpose of those structures was to reduce the tax exposure of your client companies?
So with respect to the offshore structure, the purpose of the structure was that it would mimic a non-resident trust. Back in those days, those trusts were very much...
my question was very simple. Was it to reduce the tax exposure of your client companies?
Unfortunately, it's not a yes or no answer, Mr. Fast. It's a very complex tax act. The last time I looked, it was over 2,300 pages. So with respect to the offshore structure very much operated like a non-resident trust, which was very much accepted by the government. The government welcomed those types of structures because they allowed for wealthy non-residents to move to Canada and establish residency in Canada.
Okay, so it is about reducing tax exposure of your clients.
Mr. Fast, there's with respect to the offshore structure, again, it's very complex and it's not just a yes or no answer.
Well, you know, I hate it when accountants try to hide behind complexity to avoid answering questions. Let me ask you, why was the program terminated?
The program was terminated because we very much felt that the landscape was changing, and so we very much felt that it was legal, and it also passed the GAR testing. At the time, KPMG was very much changing its views with respect to tax and what was acceptable from a responsibility perspective, and the world was changing also with respect to what was socially acceptable. I just want to point out, and I appreciate that I'm getting the sense that everyone feels that I'm not being cooperative. It's not my intention. We are here voluntarily today, and I'm providing all the information that I'm able to provide. I think that you have to appreciate that my code of conduct precludes me from discussing specific client situations.
I never asked you to discuss specific client situations. I just asked you a very general question about the tax consequences of the OCS program. Now, I did want to ask one more. You've served notice of liable on the CBC for its reporting. But your firm did face legal sanctions in the U.S. from the advice you gave to clients respecting offshore structures. Is that correct?
I'm not familiar with what occurred in the U.S. I'm not connected with that matter whatsoever.
You have no knowledge about that at all? Is that what you're telling me?
I do have knowledge of it, Mr. Fast, but okay, I don't have details. I don't have details.
For details.
Mr. Fast, if you could give Ms. Lacavelli time to respond.
Well, I think it was a yes or no answer, Mr. Chair.
Look, we try not to get into yes or no answers. You know that. Ms. Lacavelli.
I understand that our U.S. member firm did face penalties with respect to that occurrence, and I do understand that it had implications with respect to the types of services it was able to provide.
Okay, I thank you for that answer. Now, reflecting back on what's happened, I know you don't admit culpability for these frauds. I understand why you do that. But reflecting back, is there something you could have done to prevent these frauds from occurring as an accounting firm, as a consultant to your clients?
With respect, again, with CINAR and with the sword companies, we have no connection, whether directly or indirectly. I'm a tax advisor. I'm not a specialist with respect to fraud. And I couldn't begin to even explain how to prevent something like this.
Now, you did say that.
Last question, Ed.
All right. You did say you had done an extensive review. KPMG had done an extensive review of steps that could have been taken. Can you tell us this extensive review you undertook? Did it actually provide you with some information as to what additional protection could have been implemented to protect vulnerable Canadians like Ms. Watson?
The extensive review we undertook was to determine which clients sat under the OCS structure. Back in 2017, the CBC approached us again with respect to the sword companies. Again, we spent thousands upon thousands of hours reviewing our files, hard copy files, electronic files, conducting forensic reviews within our systems to determine if those clients were our clients. And I can very certainly say that they aren't our clients. With respect to your question as to what can be done, I think that we've seen lots of measures put in place with respect to the common reporting standards. There's been lots of global standards that have been in place as well. There's exchange of information that's provided, including the packet exchange with the U.S. The most recent budget included a new form of disclosure requirements with respect to transactions. Also, from a corporate perspective, there's disclosures with respect to foreign affiliate reporting. So there's an extensive amount of disclosures that are required with respect to offshore accounts with individuals or corporations.
We are going to end it there. Here's the lineup. If we're going back to the top of the round, I have Mr. Fragiskatis for about 5 minutes. Mr. Kelly, if you want to go to the top of the round, followed by Mr. Fraser, followed by Mr. St. Marie, wrapped up by Mr. Julian, about 3 minutes each in those last four. So, Mr. Fragiskatis.
Thank you, Mr. Chair, and thank you to the witnesses. Mr. Cohen, interested to hear your perspective, particularly because you have an international focus, or the organization has an international focus. Can you let us know which democracies really stand out as far as efforts put in place to meaningfully address tax evasion that Canada can look to in terms of making improvements and building upon things that that we've done in recent years?
Thank you for the question. For overall tax evasion, that I wouldn't be an expert in so much as the kinds of information exchanges that Ms. Iacovelli pointed out to. But in terms of beneficial ownership, registries and where the trend has gone, the UK was the first country to establish a publicly accessible registry, followed by the European Union setting out Anti-Money Laundering Directive 5. So all EU members have to have a publicly accessible registry. Now, some are at different scales of that procedure. And then, as I mentioned in my opening, the UK Crown dependencies and overseas territories felt pressure from that, or felt cooperation from that, and so followed on. So it's not just those countries as well. The Open Government Partnership, a number of countries have signed on there to establish registries. Countries like Mexico and Kenya are moving towards registries. The Extractive Industries Transparency Initiative, which Canada sits on the board or chairs and contributes funds to, it has required all 54 members of it who have signed on to disclose beneficial ownership information of companies seeking oil and mineral rights, and they suggest to their members to have a beneficial ownership registry as well. So in terms of that tool working towards helping fight tax evasion, it's a growing and growing number of countries, including some of the countries that are listed as the worst tax evaders. And then the United States just recently passed the Corporate Transparency Act that will have a centralized private registry. So the amount of countries that tax evader would want to move their funds to, where a crooked politician couldn't just dive into their bank account, is shrinking and shrinking progressively. So it's good that Canada has joined that group.
Well, I very much agree with you, and judging from everything that you've just said and based on your initial testimony, it sounds like there's a certain momentum that has developed within democracies to address the issue. Do you think that's a fair observation?
Yeah, I think that's a very fair observation.
Okay, thank you very much. Ms. Watson, thank you very much again. My colleagues have absolutely done the right thing and thanked you for appearing here today. They've been very sincere and for very good reason. I think it takes a great deal of courage to be an advocate as you've become. And I do want to pay attention to the human side of the equation. Certainly, there are policy issues and implications that are at play here. But you've become an advocate, and I know there are many other advocates as well, but you've become one of the voices on this issue in Canada. Can I ask you, those that you've had a chance to get to know through your advocacy, and you did mention some of this in your testimony earlier, but I wonder if I can ask you to expand on that. I think it's important for the committee to understand the human side to this truly. How are they doing? How are those that you've met along the way doing, who have been victimized and that you know and that you've met? If you can elaborate on that, that would be helpful.
Thank you. Well, it's been 16 years since the fraud was uncovered. So most of us have tried to move on with our lives. A number of our victims passed away because in our investment, you had to have at least $50,000 to invest. So most of the investors were, people in their 50s and up. So we've lost quite a few. I've heard incredible stories. I mean, a man who survived Japanese prison camp. He was married to a Holocaust survivor, an incredible man. The people that I've met along the way have been so kind and so helpful, so grateful for what I do in keeping them informed or have kept them informed. Was a well-known singer in Quebec who kept his story private for a long time until we had a meeting and he met a number of the other victims, and he realized that these were ordinary people, that they were businessmen and doctors and lawyers and dentists and professionals who, were victimized the same as he was. And so he told his story publicly. We did everything right. All our financial representatives were registered with the AMF. They were all in these professional associations. Mount Real was listed on the stock exchange. There was nothing to suggest that this company was an enormous Ponzi scheme until it was too late. But
okay, we will have to end it there. I'm sorry. We'll go to a couple of minutes each from the following: Mr. Kelly, Mr. Fraser, Mr. St. Marie, Mr. Julian, and Miss May. Mr. Kelly, floor is yours. Do you want it, Pat? Or who's taking it?
I believe, Mr. Chair, I'm taking this round.
Okay, Ed, you're on.
Thank you. Just one quick question of Senator Down. You mentioned that the PBO can't get CRA's cooperation to do a full tax gap analysis. Is it a matter of resources? Is it a matter of training? Is it a matter, what's the problem here? Do they not have the skill sets to be able to do that?
Well, if you ask the PBO, and I'm sure you'll have him as a witness, he'll tell you it's a lack of cooperation. The PBO has sent out detailed plans of the information they require. And again, it's not personal information, it's the collective information. And they ended up getting a legal opinion advising CRA that they had the authority to do this, and the CRA has refused to budge and nobody has intervened.
And our members have not been asked to do this work.
Okay, so
I was going to ask you, Ms. Stabio, if you wanted in. Go ahead, Ed, sorry.
Yeah, so is it, again, Senator Down, is this a matter of a political unwillingness to do this?
Well, that's a good question. I don't know. What the CRA has ended up doing is they've done 6 individual tax gaps, and even that has shown between 20 and 24 billion dollars is missing that they're failing to collect. I can understand why they don't want to do an overall tax gap, but given the record of misleading information of the CRA, and I have a long list of examples of those, it's best if an outside group does it. And in this case, the PBO is the group to do it. Mm-hmm. I think this is the 3rd PBO that has been trying to get the information.
Mr. Campbell, you mentioned there's $25 billion that could be available if the proper tools were in place. And you mentioned 2 specifically: formulary application of profits and unitary treatment to address transfer pricing. Could you just quickly comment on those 2?
Sure. So formulary allocation of profits. What you're basically doing is choosing different criteria to ascertain what amount is going to be taxed. This is already done in Canada to determine which province a company should be taxed in. I think the criteria used is payroll and sales. So you look for that economic substance and then tax accordingly. There was unitary treatment of international multinational corporations, so that there can't be the shifting of profits within their own supply chains in a way that's advantageous, meant solely to be advantageous in a tax for tax treatment, as opposed to accurately reflecting where the commerce takes place and therefore allowing it to be taxed in the appropriate country and go into the and fund.
Okay.
Sorry, Ryan.
Yeah,
that was my outside voice.
No. If you want to go ahead, and then what I wasn't allowed. There was one last aspect to the combination of policy prescriptions that would help reduce profit shifting and transfer pricing, and that is it's been used in other countries, or it's starting to be implemented in other countries, which is the idea of a global minimum tax for corporations. So your international cooperation to make sure that corporations are taxed fairly everywhere, and they're not, skirting responsibilities everywhere.
We're way over where I wanted to be, Ms. Davio, but go ahead very quick.
Very quickly, just in plain language, what this means is that you have, basically a shell company set up in a country where the tax laws are advantageous. Nobody even works there. Sometimes there's not even a physical workspace, but that is the country in which the profits are being taxed in, as opposed to where they're being made here in Canada. And sometimes our resources are being taken for these profits that we don't even get taxes on.
Mr. Fraser, about 2.5 minutes.
Thank you, Mr. Chair. I sent a note to our colleague, Ms. May, indicating I'd be willing to cede my time. I don't want to see her get cut off with the rump you've saved at the very end, so I'm happy to pass it over. Should Mr. Campbell or Ms. Davio have the opportunity to advise on what steps we can do to support efforts towards a global minimum corporate tax, I'd be interested in your advice. But I'll.
Okay, Ms. May, we'll go to you.
Thank you.
Mr. Fraser.
I'd love to give Sean back some time. I'll try to be really brief. I've been troubled for decades by consistent reports from the Auditor General's office that CRA does not take their efforts to go after fat cats with complicated structures and lots of lawyers as much as they go after little guys like my friends or auditing my daughter as a university student. You have to wonder. So as experts in how CRA operates, to PIPs, either Ryan or Debbie, and then to Senator Down if there's time, is there a cultural problem within CRA that's deep and systemic that both through resources and culture would rather go after Canadians of limited means than complicated, well-heeled tax evaders?
I personally don't think so. I think it's a question of not enough resources, not enough supports, not the right organizational structure in place to maximize our ability to go after international tax cheats. Maybe Ryan has something to add.
Yeah, I mean, my interaction with auditors, which is quite a few, is that they're driven by a deep sense of fairness, and it is what they want is a tax system that's defined by integrity and fairness, and nothing would make them happier than having rules that would allow them to, and the resources to go after the big time tax cheats, the ones who are trying the hardest to avoid taxes.
Senator Down, did you want in on that one?
Sure. It's a senior management of the CRA, and I have a long list I can send the committee if you're interested. Let me give you one example of the problem with CRA. They announced in 2017 that 90% of calls to the agency were successfully connected to an agent and automatic helpline. The Auditor General investigated that and found out that they blocked 29 million of them. So that meant that the overall success was 36%. Now, what agency of government thinks it's acceptable to claim 90% when they block 29 million of the calls and then don't include them? There's a long, long list of how they conduct themselves. I have not seen it anywhere else in my experience in provincial or federal government where an agency or a department of government operates this way.
Okay, we will have to move on. Mr. St. Marie, Gabriel.
Merci, Monsieur le Président. Madame Iacovelli.
Thank you, Mrs. Iacovelli. I remind you that with regards to the powers conferred to the committee, this act has precedence on professional secrets. You can look at the professional chartered accountants ethics code. Now I'm going to refer to a journalist article from published at Radio-Canada last April, and they remind that through the Paradise Papers leaks, they found internal redacted emails by Sandra Georgeson, an administrator that was acting on behalf of many client companies. In an email in December, it's called a manager asked who was the promoter of the scheme, and she said that it was KPMG Canada. Do you recognize this as being truthful?
Ms. Iacovelli?
I'm sorry, I'm not sure that I fully understood, but was it with respect to the offshore structure? I'm not sure that translation's coming through clearly.
Do you want to just quickly summarize that again, Gabriel?
Oui.
Yes. So in the Paradise Papers leak, the journalists remind internal emails written by Sandra Georgeson that say that in the end, these client companies on the Isle of Man for Canadian clients, she said that KPMG in Canada was the one that created this scheme. Do you recognize that as being truthful?
I think that we've always been forward about the fact that we created the offshore structure, but there's also, with respect to the Isle of Man, there are other offshore structures that were available at the time that were non-KPMG offshore structures.
Dans ce courriel-là, Sandra George.
In this email, Sandra Georgeson has a spreadsheet that creates a list of companies, and the 4 sword companies are on the list. And this has to do with the CNR scheme. And so CNR, North Shield, and Montreal, I know that you're dissociating yourselves, and these 4 names are linked to KPMG Canada, but you're saying that there's no direct or indirect link with KPMG. That's what you're saying.
Ms. Lackavelli.
That's correct. We are not in any way connected to the sword companies. I think that there's a few emails where Ms. Georgeson actually contradicts herself. There's one email where she says that Corderi was only the service provider for KPMG, when we know that Corderi was also the service provider for 9 other non-KPMG OCSs, and was also the service provider for the sword companies, which we had no involvement in. She also goes on to indicate that the service provider provided other services and not just the OCS services, when she contradicts herself, saying that that was the only service that she provided. She also goes on to say that the OCS was unique to KPMG. We know for a fact that it wasn't unique to KPMG. There's all sorts of OCSs that are provided within the Isle of Man. I think that with respect to Ms. Georgeson, I'm not suggesting she's lying. I'm suggesting that she's an administrator who was doing her job, but really didn't provide the same level of due diligence that we would have in terms of searching out who and who was included within the KPMG offshore companies. We've done extensive searches within our databases, Mr. Saint-Marie, and we've spent hours upon hours in terms of searching our databases, including forensic reviews. We've involved external legal counsel as well. We've interviewed everybody involved with the offshore structure.
I'm going to interrupt you. In the article, one last quick question. Did KPMG Canada already have as a client North Shield and Montreal?
With respect to Montreal was not a client of KPMG. With respect to North Shield, we were the auditor of a fund that's in a chain of funds with respect to North Shield. That fund was Olympus. When we were the auditors, there was a sophisticated fraud that was undertaken at Olympus. And unfortunately, we didn't uncover that. The fraud involved an inflation of asset values, which my understanding is different than the fraud that was undertaken with respect to CNR and the sword companies.
Okay. We'll let you finish. We'll let you finish, Madam Lackavelli.
Thank you. So RSM were the receivers with respect to that Olympia fund, and their view was that we should have caught the fraud. Unfortunately, we did not catch the fraud, and we did settle with respect to Olympus, and we paid $7.5 million to the receiver. RSM were also the receivers when there was no redemption reimbursed with respect to the funds. We looked very carefully at this. There is no connection that we see between the Olympus Fund and CNR.
Okay, we are going to have to go to Mr. Julian Peter. Peter, you're muted.
Désolé, Monsieur le Président. On a besoin de plus de temps pour questionner.
Sorry, we need more time to question these witnesses. a lot of important testimony here, especially to see the actions of KPMG following the revelations that we had at the end of February from Fifth Estate and Enquête.
This issue from in your own testimony, Ms. Iachiavelli, you have stated that on the record that shell companies, client companies, were not offered after 2003. And so you have also in the past, KPMG has validated that it was behind, the Montreal office was behind the incorporation of Parrhesia on December 17th, 2001, at the same time as the sword companies. Now, since this wasn't offered since 2003, imagine my surprise when we went online to find out when Parrhesia was actually dissolved. It was dissolved 43 days ago on March 24th, 2021, just 3 weeks after the bombshell revelations from Fifth Estate and Enquête. How can KPMG pretend they weren't offering that after 2003 when the corporate registry says very clearly that it was only after Enquête and Fifth Estate came forward that the company was dissolved?
Ms. Iachiavelli.
Mr. Julian, I don't have any information on that entity.
But you understand that it contradicts all the testimony that you've given us today when you say that it's a product that hasn't been offered since 2003, and we can look on the corporate registry and see that just after revelations came forward, that this is when the company was actually dissolved. There's a whole host of unanswered questions, Mr. Chair, so I would like to move that we extend our witness time until the end of the meeting so that we can continue to ask these questions.
Okay, it is a motion on the floor, and as a chair, I am going to speak on this, and you can rule me out of order, but. We had a meeting scheduled for 2 hours. We're over that. If anyone thinks that we're going to solve this problem with another 20 minutes, we're not. We have the opportunity to call another meeting. And my judgment call, I try to be fair, but we agreed as a committee that we would do the Budget Implementation Act. We would turn to it when it was tabled in the House. And we now know that we had to farm out about 12 divisions of Part 4 to other committees. I've tried to get a steering committee meeting for Monday. We couldn't get it. I've asked the clerk to check if we could get any other time next week. We can't get it. Now, honestly, folks, if we cannot deal with this motion on the BIA today, then we can't do anything till Tuesday at a regular meeting, when we're really going to try and see if we can get the minister there on the Budget Implementation Act, which is important to Canadians in terms of the issues that are in the Budget Implementation Act. And in fairness to other committees, if we don't allocate out to them the work that they have to do, I don't know when they're going to get time to do it, because we've got 24 hours booked on the break week for this committee. So that's what we're up against. I hear your motion, and I know I shouldn't as chair talk against it, Peter, but based on my judgment, I think we're been unfair to other committees. I think we're been unfair to other Canadians. If we don't deal with the issue that we should as a committee on the Budget Implementation Act today. That's where I'm at. I think we can call another meeting on this issue as soon as we get the BIA out of the way. But that's where I'm at on your motion, Peter, and I know you could fire me as chair for that, but that's my view, and I feel fairly strongly on it. So, okay, there's a motion on the floor.
And I'll just briefly speak to it. Hopefully we can get back to the witnesses, Mr. Chair. And I don't question your wisdom. This is a very complex motion that was given just a few minutes before the meeting. Not even every member of this committee has read it. We have to consult as well with our caucus and with our critics. I mean, it's simply unfair to try to ram this through when we haven't had adequate notice. Normally it's 2 nights, and I can understand everybody's busy, but do notice. Respect for the committee is important, and I think if you try, you will be able to get that Monday steering committee meeting, and that will allow us to bring a recommendation to Tuesday. I'm not trying to delay anything, but we've got important witnesses here, and I think we should just spend the rest of our time on the witnesses. We can deal with this motion when we've actually had time to consider it.
Point of order, Mr. Chair.
Go ahead. Mr. Fraser, and then I have Mr. Fast on my list. Mr. Fraser, point of order.
Just wondering if the clerk, I'm happy to speak to the motion when it's my turn, but on the point of order, I'm just wondering if Mr. Clerk actually have the technical ability to sit later than this evening. Is that something we could do to accommodate additional questions members may have for witnesses and preserve the ability to discuss committee business today?
Alexander?
As I informed the chair before the meeting, the cutoff time before the committee starts impacting other committees that sit later tonight is 6 o'clock. If we go later, the whips will have to decide which committee is not meeting tonight.
Okay, I have Mr. Fast. That's the answer to that one. Could I ask the clerk as well, what's the situation for next week in getting time?
There is no room next week for additional meetings whatsoever. I tried on Monday, and Status of Women already took the spot that was available Monday evening. So there's no more room on Monday, and I looked with the services and I asked my management, and there is simply no room next week for additional meetings at any time.
Okay, we're still on the motion then, Mr. Fast, Mr. Fragaskatis, and Mr. Kelly, and then I'd like to call the question.
Well, Mr. Chair, let me start off by saying I've always appreciated your even-handedness at committee, and so this is not a challenge to you. I do disagree with you, though. This motion from Mr. Fraser, it's a very significant motion, and it was sprung upon us today. And quite frankly, we've got these witnesses here on a very important study. I'm sensing we've just scratched the surface with these witnesses. If we have another 20 minutes, I think we can use it productively to get additional information that's really going to be helpful in crafting a report that comes out of this.
We're down to 17 now. Mr. Peter Fragaskatis.
Chair, I don't dismiss for a moment that we've heard important things today. And as you said, we can have other meetings on this after we deal with the BIA. But as I'll remind, especially my colleagues who sit on the subcommittee with me and with us, we agreed that this meeting would be 2 hours. We now have exceeded that. And we do not need to have a notice of motion given on matters of committee business. My colleagues are experienced and will know that. I'm surprised that they're raising a point of view to the contrary. So we do have an important issue to deal with that Mr. Fraser has put forward, and I think we should move in the direction of looking at it.
Mr. Kelly, last word to you, and then I hope we can go to a vote. Sorry, Pat, you're muted.
You can go ahead and call the question, Mr. Chair.
All right, then we'll go to a recorded vote. Mr. Clerk, if you want to call the vote.
Ms. Derowitz.
Could you read out the motion?
Do you want me to do it, or would you like the...
Yes, you could do it, Mr. Clerk.
Mr. Julian moves that the meeting be extended to continue the questioning of witnesses until 6 o'clock. Is that right?
Yes.
Point of order, Mr. Chair. Can we ask the witnesses if they're available to stay any longer? I mean, I don't know if they have other commitments, but we're assuming they can stay. But
it's only 15 more minutes now on that end. I don't see them jumping up and down. Ms. Zerowitz, we're into a vote, so we can't take a point of order.
No problem. So no.
Mr. Fragiscatos.
No.
Mr. Fraser.
Against.
Ms. Katrakis.
No.
Mr. McLeod.
No.
Mr. Falk.
Yes.
Mr. Fast.
Yes.
Ms. Jansen.
Yes.
Mr. Kelly.
Yes.
Monsieur Sainte-Marie.
Oui.
Mr. Julian.
Yes.
Yeas pour 6, nays contre 5.
Okay, then the motion is carried. We got 14 minutes left.
Mr. Chair.
Yep.
I know it's totally inappropriate for me to enter into the debate, which is why I waited until now, but we've been sitting in front of our computers since 3 p.m. So if we're going to continue even for another 15 minutes, I'll require a health break.
Okay, you you take a. Well, hopefully you take a health break, Ms. Davio. That's fine. We'll see where the questions go. Will anybody who wants to take a health break go ahead, and we'll go to questions. Who wants to? The first one's up will be. We'll get time for one question each from Conservatives, Liberals, Bloc, and NDP. I'll figure that time out when I divide it down here. Who wants to go for the Conservatives, Mr. Kelly or Mr. Fast?
Well, I'm going to suggest Mr. Falk go on this one.
Okay. How could I get it wrong? Ted, you're up. And it'll be about 3 minutes, Ted, I think.
Okay, thank you, Mr. Chair. And Senator, I'd like to ask you a question. In the Prime Minister's 2019 mandate letter to the Minister of National Revenue, the Minister was instructed to seek new ways to counter tax avoidance and evasion by wealthy individuals, enhance existing tax avoidance and evasion whistleblower programs, and look for more opportunities to invest resources to crack down on tax evaders. When you look at the last 5 years, how would you describe the government's progress in these areas?
Well, it's much more than 5 years. It goes back to at least 20 or 25 years. We're just finding out about the leaks over the last number of years. These disclosures literally didn't happen until recent years. And then the CRA had to adjust to that new reality, as did the government. For example, the Liechtenstein list of disclosure, the 106 Canadians who had accounts there, that leaker sold the list to the government of Germany, and then the government of Germany offered it to other countries who had citizens on the list. So the government of Germany gave it to the government of Canada. The point I would make is the point I made in the opening remarks. You look at other countries and what they have done. I think the Australians were the first off the mark. They quickly recognized that once you start charging people and convicting people and see names of friends and neighbors going to jail, the appetite to invest and to hide money overseas drops dramatically. So it's that culture of resources and criminal activity that has been under the radar screen. So it's been going on for a very long time.
Okay, thank you. And what would your recommendation be to correct that problem?
Well, there's a number of things that have been done. I originally was part of the group that thought we needed more funding for CRA. The funding has been given over the last number of budget. Granted, all of it hasn't been spent, but it's a significant influx of funding. We find that some of that has not gone towards overseas tax evasion like it was said it was going to. I've come to the conclusion of late that we need a supervision over the CRA, and that should come from the Department of Finance. We saw in the recent budget, the Minister of Finance, in her own initiative, I understand, did the most significant advance on tax evasion. That's a beneficial ownership initiative in the budget, where she indicates over the next 4 years, they committed $2.1 million to set it up. If this can be done sooner, it's even better. As others have mentioned, we need cooperation of the provinces, but this is the most significant development in the years I've been looking at this file to fight tax evasion that has been done. We just need to have it completed and implemented.
Okay, I'm sorry, Ted, we are going to get in there. Who wants to come forward from the Liberals? Because I don't have a list. While they're thinking, Mr. Fragaskatis, did I see you? Okay, we'll go to Mr. St. Marie and we'll come back to you. Somebody give me their hand from the Liberals because time's have passed. Mr. St. Marie.
Oui, ma question est pour le sénateur.
My question is for Senator Downs and for Mrs. Watson, Mr. Campbell, and Mrs. Devio if she comes back, and also Mr. Cohen. The allegations, and if we look at the CBC Radio-Canada article that seems to indicate that there could be a link between KPMG and the four sword companies from the Isle of Man. The journalists seem to indicate that there is a link, and KPMG here is saying that there is no link. Who is correct in your opinion? Thank you.
I'll start by saying I have no idea.
Senator?
I'm the same. I've only studied the CRA and what they have done, so I haven't followed this at all.
I'll say that I'm the same. I don't know enough of the details of the cases to know.
Okay, Madame Watson.
I would say that I think that that Mr. Cashore of the Fifth Estate has been working on this since 2016, and I think there's a lot of very important coincidences. There's also been tax experts on the show that said it was too much of a coincidence. So yes, I would say there is a link.
Je vous remercie, Monsieur le Président, ça complète mes questions.
Thank you. Those are all my questions.
Thank you, and we'll come back to Mr. Fragaskatis for 3 minutes, and then Mr. Julian will wrap it up.
Again, to Mr. Cohen, if I could. Mr. Cohen, what would you say would be the absolute or ought to be the absolute priority of the Canadian government to meaningfully address tax evasion? You have pointed out that some significant steps have been taken in recent years, and also the most recent budget provides a promising path forward. But if you're going to prioritize anything as far as recommendations go, and also based on the experience of what we've seen internationally with respect to democracies that you spoke about before, what are the key things?
Thank you for the question. I think I would say two things. Not to repeat myself, but the beneficial ownership registry, I'd agree with Senator Down. If we can get it before 2025, that would be excellent. We're coming to halfway through 2021. There needs to be discussions with the provinces and territories. So there is time that is required, but let's see if we can be optimistic and get it done quicker and to the best standard possible with ID verification, with proactive investigations, with a tip line. I would say the second point would be to echo to our colleagues from the Public Service Union and talk about reintegrating expertise into the right areas and looking at how the dissolution of specified units affected the capacity of the CRA to look at overseas tax avoidance. Without knowing the specifics of that case in CRA, it's definitely anecdotally something I've heard from a number of investigators across Canada about the lack of specialized units and issues of corruption, more specifically, and money laundering. There's a trend to have a specialized unit and then dissipate it across other units, and then that expertise gets wound up in other cases, as opposed to putting a priority on anti-money laundering, on tax evasion, and on corruption. I know we've been hearing a lot about complexity, and people don't want to hear that as an excuse, but between mutual legal assistance with sometimes uncooperative jurisdictions, the sheer terabytes of data that is involved in some complex white-collar crime cases, these specialized units are required. So the beneficial ownership registry, getting that on track and doing it to the highest quality possible, and looking into the ability to reorganize the capacity of specialized units across authorities in Canada.
Well, it is unfortunate that cuts to the international focus did happen 10 years ago, as we heard before under a previous government. But I think the past is the past. We have to focus on what is needed now, and the budget does provide a promising way forward, as we have heard. Mr. Chair, do I have remaining time, or is that...
You really don't.
I really don't. I didn't think I did.
You
see how I try to sneak that in there. But,
yeah,
no, that's fine.
you had 20 seconds, but
no.
I would say, just for the information of everyone, that on the beneficial ownership registry, it was all-party agreement, I believe, in 2017 at this committee, when we did the money laundering study, that it was recommended. Peter, you have about 3 minutes, and you'll wrap it up.
Thank you very much, Mr. Chair. And I beg to correct you. The beneficial ownership registry was supported by the other two parties. The NDP pushed for a publicly accessible beneficial ownership registry. And as we can see from the report on snow washing, that was declined by the other parties. So I'm very glad to see that the idea of a publicly accessible beneficial ownership registry has now come back. I wanted to come back to Ms. Iacovelli. There are two, for Parisia, two directors, Nigel Glazier Scott and Paul Joseph Valentine Dougherty, who are directors of Parisia, that was incorporated by KPMG, and as I mentioned 43 days ago, similarly dissolved. Those are the same directors that were for the sword companies. So could you tell us if there's a connection between these two individuals, Nigel Glazier Scott and Paul Joseph Valentine Dougherty, and KPMG?
With respect to the fact that they were the same directors. Again, it speaks to what the corporate service providers offer. They set up these corporations and corporations. They prepare documents, articles, and they provide shareholders. They also arrange for managers, shareholders, and directors. So I'm not surprised that they would be same directors. Corporate service providers make all of those arrangements.
Okay, and
Mr. Julian,
sorry, I have a follow-up question. And who was the corporate service provider that set up Parisia?
I can't speak to Parisia. The corporate service provider that we worked with was Corderi. And again, Mr. Julian, can I make a clarification from something?
Go ahead, Ms. Iacovelli.
Thank you. I just want to clarify that we stopped offering the product in 2003. 2003 was the last time that we offered it. We did not manage the structure post that. So I don't have information as to when any of these were dissolved. So I just wanted to make that point of clarification. But we have provided the CRA all of the information with the 16 implementations we've done.
Well, we will certainly come back with other questions. I wanted to save my last question for Ms. Davio. We certainly appreciate the professionalism of PIPS. Your members are extraordinary. You've raised a whole range of areas where we could actually improve providing supports to PIPS so that they can actually do the work that they want to do. But what we've seen from CRA employees is that they don't actually have the legislation in place, so that they're not outgunned by these big players. Would you also add legislation with teeth to the list of things that you've given us in terms of improvements that would actually mean that PIPS members could do the work that they want to do on behalf of Canadians?
Yeah, 100%, Mr. Julian. We would, first of all, thank you for the compliment. I agree. I think my members are amazing. They're incredibly passionate about the jobs that they're being asked to do on behalf of Canadians, but they need some help. They need the government to take a look at gaps in legislation. Those gaps are easily seen when we look at, court cases and the resulting court cases and where the CRA is losing as a result of those gaps. We've offered even to some of the MPs on this committee that we had the opportunity to meet with that we'd be happy to work with our auditors and decision makers to try to identify or zone in on where those gaps are. But at the end of the day, for us, the most important point raised by Mr. Cohen is that investments need to be made not in the number of resources, but in how those resources are structured and how those people are able to access the right tools and training to be able to do the job they're being asked to do.
Okay, we will have to end it there. I do want to very much thank witnesses for their presentations today and spending the extra half an hour, which wasn't scheduled. And with that, I will be back to committee and how we go forward from here as soon as possible. So with that, meeting adjourned. Thank you all.
Thank you.